Hello and welcome to the Bennett Griffin Family Podcast. We're hoping to enlighten and entertain you, maybe, as to issues which commonly arise in family law, based on my experience as a family lawyer. I'm Jacqueline Menser, and also the experience of my wonderful colleague, Sarah Pennicott. Hello, Sarah.
Hello.
So we've got a series of podcasts. Today, we're going to focus on a particular area which we found crops up quite a few times with clients or potential clients, in that quite often people say to us, why should I actually take advice from a lawyer? I can do it myself, it would be a lot cheaper, there's nothing complex, and basically, why do I need you? Do you find this as well, Sarah?
I do, and I think it's become more of an issue in recent years as the courts have made the divorce process and the divorce petition more accessible to a layperson. There is the assumption that people don't need any legal advice at all to deal with a divorce, but there are so many other issues that can come alongside the actual divorce petition itself. So the financial issues, the children. And it is really important, I think, to get legal advice early on, to know that you're completing the forms correctly, but also to know what your rights are and to make sure that you're protecting those as far as you possibly can. I think very often we speak to people who say, well, my ex has threatened to go to a solicitor. And I don't think it should be seen as a threat. I think it is really important that it's not seen as an acrimonious step. It is a process that we can help you with. And quite often, actually, we can make the whole process more amicable.
Yes.
Because we can make it more objective or help you to see things more objectively, and make the process run smoothly and avoid the common pitfalls that we see when people do their own divorces without any advice at all. Jackie and I are both members of Resolution, which is a group of family solicitors who have the aim of making the divorce process and everything associated with it constructive, because we know that as you move forwards in your life, particularly if you have children, your ex is still going to be part of your life. And it can be very acrimonious at the point of separation. But if you can move on from that in a constructive way, it's going to benefit everybody in the future. So, as I say, it doesn't have to be seen as an acrimonious step to seek advice. And it's important, I think, to break that myth that we're scary and aggressive and will fight tooth and nail, because that's not the case. And it's usually the case that we'll try and help you to find a solution that works for you.
Yeah, I think that's absolutely the case, Sarah. And it's also that it's about fairness. It's making sure that you actually achieve the fairest result, not just for you, but also for your family. But it's also about ensuring that you really reduce the stress and the strain as much as possible, because believe it or not, there can be a calmer way of dealing with things. And that's what we're about. And that's what Resolution is about as well. It's taking the heat out of it. It's often the case that whether people like it or not, because you're dealing with such sensitive issues, whether it's a breakup or matters concerning children, that there's a huge amount of emotion involved. And if you're the person in the eye of the storm, it's really difficult for you to deal with that. Whereas we come on board, we can act as the buffer. Basically, use us to protect you. That's what we're there for. We will calm it down. We will give you proper, sensible advice, and you'll have those options at the earliest possible opportunity.
Yes, yeah, and I think in terms of calming it down, sometimes quite often where people are dealing directly with each other, they can get very focused on one small argument that actually in the grand scheme of things may not have a huge impact. And I think, or I hope we can help people move on from that. And resolve things, because sometimes you get so stuck in a cycle that you need somebody to help you break that and to progress matters.
Yes.
Is there anything in particular you see coming up in the divorce petitions that people have prepared themselves that is commonly an issue?
Yes. Well, I had a lady come to me quite some time ago who was a care worker. This was way back before the pandemic. And she had children. She had a busy lifestyle, like so many of us. And she basically came in and showed me the letter she'd received from the court concerning her divorce petition, which she had filed herself. And she thought, this will be easy. It's all agreed. I'll just send this in. Job done. I think she was working nights as well. So she had a lot going on. So the letter had easily 10, 12 points, which the court had knocked back, saying she needed to amend the petition, she needs to do this, do that. It was difficult to even decipher what the letter was asking, what was required of her. And she said, I just can't deal with this. This is too much. She said, I have no idea what they're asking me to do. I'm just going to hand it over to you. I should have actually taken legal advice from the start, should have just got you to represent me. So that was one where she thought drafting it herself would be the answer, but actually it was more complex than that. Also, in terms of divorce petitions per se, in terms of things that you have to tick and things that you have to do, and a lot of it is just procedure and it's what the law says. There may not appear to be any logic to it. So in the prayer, the actual section of the divorce petition, where you're asking the court to have a look at the things that you want it to do, and you would like it to do, you're requesting those elements. There is the box as to whether you wish to pursue any financial claims effectively. Now, this is a bit of a red rag to a bull to some clients and the other party, because they think we've agreed the finances, it's all done and dusted, or there's nothing to be looked at anyway, we have no assets, therefore I'll just ignore that bit, or I may not have even seen that bit, and it doesn't make any sense to do anything with that bit. What this means, if you do miss that, is that later on you may have to apply to be able to apply to make an application about the finances if in fact you can't agree the financial issues. And it may not be apparent at that stage that there is an issue. So it's absolutely best common sense and our advice to ensure that that is included and ticked, just as a coverall, just as a backup coverall, even if you think it doesn't make a jot of difference to me, there's nothing to fight over. So that you don't have problems further down the line, because quite often it's not the actual initial work which costs you, it's the remedial work.
Yes.
Trying to put something straight, and it's not just the actual work with amending a document, it's the repercussions potentially of what that could mean if you can't salvage it.
Yes.
So that's quite a common one, and I'm sure you've come across that as well.
Yes, and I think in terms of the divorce petition, commonly if something's been missed, like you, I've had several clients come in who have started the divorce petition and then it needs to be amended, and what they haven't realised at the outset is it's not just a case of changing it, you have to almost restart the whole process.
Yeah.
And there's a further court fee to amend the petition. So not only are you adding to the cost of it, but you're also adding to the delay, and you can turn a process that would take normally 4 to 6 months into 10 to 12 months. And at the time of a divorce, usually people want it resolved as quickly as they can.
They do.
They don't want it to be dragging on that much longer. It will also then impact on when you can get a financial order, because that's then pushing back that day. So there's so many knock-on effects that actually getting that advice early can help you to avoid. I think the other thing that people miss when they perhaps when they start to do the divorce themselves is that they need to review their will.
Yes.
Because at that point, what they're focused on is the divorce itself, and they don't think necessarily about the aside issues. Whereas if we give them advice, we'd be steering them towards our wills department to even just have that initial chat about whether they need to do something now or when they're going to do that. Ownership of the property, whether they need to change how that's owned jointly and become tenants in common, which is a whole other conversation. But knowing their position, that is really important. And although they may be able to do the divorce process themselves, it's those side issues that can easily get missed.
That's right. It's the signposting, isn't it? And that's what we're good for as well. Basically, the public need to use us in that respect, because not only do we have that particular legal knowledge, but we also have great contacts with other professionals, trusted professionals. So within the Bennett Griffin team, we've got a fantastic wills department. So immediately we will say to clients, actually, have you reviewed your will situation? So it could even be that we may not do anything that substantive for them on the family side, but we say, actually, have a chat with our colleague.
Yes.
You have a look at that and sort that first of all, or at least know what your options are there. We've also got the benefit of knowing professionals outside of our firm in terms of mediators, therapists, counsellors, people that we could recommend in terms of their support and guidance and advice services. And again, then in terms of other professionals, obviously accountants, actuaries, tax consultants, that sort of thing. So there's a myriad of services that we can actually make more accessible for clients, offering that overall package and service to them. So it's a lot more than just you need to tick that box.
Yes, yeah, and drawing to their attention as well that that's something they need to think about.
Yes. That's it. And that's really what we're here for, isn't it? Not to dictate or say you must or you shouldn't do this. We're really saying this is our advice, these are the options. You can please take this away with you and decide your pacing and what's best for you. But this is, from our experience, what you need to do. So have a good think about it, have some reflection. At least if you've got it, it's there for you to have a think about. I mean, I started at Bennett Griffin in 2004, so pretty much man and boy. And I think I've pretty much seen everything, as you have, no doubt, Sarah, because I know that you've got a vast amount of experience as well.
Yes, and I joined Bennett Griffin in last September in the midst of the global pandemic.
So glad to have you.
Yes, having been at a firm in Hampshire since 2003. So a lot of these problems we see time and time again where people haven't had advice, and over the years the same issues come up.
Yeah, they do. And it's a bit like, I would sort of draw the analogy with if you tried to service your own car, that you might want to risk it, but you shouldn't really, should you?
I don't think I get very far.
I don't think it's the best way forward. There's the initial safety issue, several safety issues, and then there's the whole, I've got to actually salvage this and now pay somebody to do it properly. And that's really what occurs, that it's a false economy. It's putting you at risk, and it's a false economy in terms of the money, because even if you have an initial consultation with us, yes, you've got to pay some money, but boy, is it worth it, as opposed to way down the line when something has to be unravelled or can't be unravelled, unfortunately. I mean, that's the case also with consent orders, isn't it?
Yes, and I think that's the next thing that we see when people haven't had advice. It's a big problem, and more so we're seeing, or I'm seeing, people coming back 5 years down the line saying, well, we'd agreed 5 years ago and the other half wants more. And they've had they've got nothing formally or nothing in writing at all, or one of them has misunderstood what they thought we'd agreed. That's the other issue. So it's really, really important to ensure that any agreement is recorded in a financial order approved by the court, because your claim won't be dismissed on the decree absolute. Your claim for financial relief, it is only the making of an order or remarriage that will bring an end to any financial claims. Absolutely.
It's about entering into it with your eyes open, isn't it? Just as you do with a business transaction, having that available information before you make a decision. I recall a gentleman who came to me with a consent order, which he believed was ready for implementation. So he thought it had all been done and dusted. He hadn't taken legal advice at the outset, so he'd held himself at a disadvantage. But as far as the court was concerned, he'd had the opportunity to take that advice and hadn't done so. And it transpired that the consent order meant that he was tied in for another 5 years or so. So he wasn't going to get his money out of the family home, not yet. And he'd have to carry on paying the maintenance as well. Such were the terms that he'd apparently agreed to. And he was quite shocked. He'd come to me initially because he thought perhaps something wasn't quite right. And his former wife and her lawyers had said, no, I'm afraid you're still tied in. And he didn't quite believe it. And that is what it said. And that, that really did cause him a lot of upset, because he thought he could move on with his life. And he had to rearrange his finances again. So it's huge stuff that can impact on people for a long time.
Yeah, and I think typically they think that they understand what's in it when they don't necessarily. And I think the other thing we see is that people haven't necessarily addressed everything that should be in the order.
No.
So in some situations, pensions, they might not have been included within an order. It's another issue which arises, that people think they've, or say they've agreed, but they haven't realised they need an order in order to get the pension company to implement the pension sharing order. So you could get to the point of retirement, I suppose, when actually you haven't got that order in place. And then if you've remarried, potentially you can't bring the claim. It becomes very complicated. And if it's resolved at the time, it's a lot better for everybody.
Yeah, that's right. It's the consequential damage, isn't it? Because it's not just the value of that asset at the time, it's the income stream. And it's also the benefit to relatives and in particular children, isn't it, that could be lost as well.
Yes, yeah, exactly. And in going hand in hand with consent order, the other thing I see is where there hasn't been the necessary financial disclosure, and people have reached an agreement without full and frank disclosure, and subsequently find out that the other party had more than they thought that they had, but they've signed up to a deal that they put before the court and got into an order. And again, that's something a lot easier to deal with at the time of the consent order, rather than in hindsight when you're trying to undo everything that's already been done.
Yes, I think sometimes I've found that clients said to me, well, why do we need to know this? Why does the other side need to know this? It's not relevant. We're not looking at this. We don't need to carve this up or do anything with this. But it's the whole premise and principle of full and frank disclosure, that it's about having that information. You may not necessarily utilise it. It may not be relevant, in fact, but it's having that information so you've got all the options open. Because if you don't ask those questions and obtain that information, then you could be stuck later on.
Yes.
And it may be that the law isn't there then to help you later on, unfortunately, because if you've entered into willingly with consent into an order, then it may be that the court presumes, well, that's it, you understood what was available, or you didn't, but you had the opportunity to do so. And if we then come on board trying to help you at that stage, then you could be looking at really complex, expensive proceedings if they're available in law, in terms of setting aside something, trying to reopen something. And there's very narrow opportunity for that usually. And that's why also we would generally, subject to your personal situation, say, don't apply for the decree absolute in a divorce until everything is looked at, explored, done and dusted, you've got an agreement. That's the general premise. Because if you start cutting off your options, we may not be able to do anything about that, and you may regret it later on. And that's the whole thing. I know you just touched upon a moment ago, Sarah, about the remarriage trap.
Yes.
So a lot of clients don't realise that actually if they remarry, they're cutting off their claims, whereas it may be that their former wife or husband still has claims open to them, and they will pursue them against them regardless of their changing circumstances now. So that comes as quite a shock and surprise to people quite often. So it's really just keeping everything as open as possible and obtaining the information which can provide you with security.
Yes. Yeah. And I think that's the message we want to bring through this, is just know your rights, isn't it? We don't have to take anything any further. But it's very important that people know what they're potentially losing, or what they could potentially gain before they make any decisions about how to proceed.
Yeah, absolutely. That's it. And just come to us, have that chat, before you get into a pickle, because it may be something that we can't do anything about, unfortunately, but we'll do our best, but come to us as early as possible. Hopefully we've shown today that we are approachable. We're not too scary. I hope so. And if we haven't convinced you today, then hopefully we will convince you on the next occasion as part of our series of podcasts, because we're aiming to do a podcast every month, aren't we?
Yes.
On different topics of interest from our experience, things which really do crop up quite often. And obviously, if you want to have a confidential chat with us about anything that we've discussed today or otherwise, then our details are on the website, and we'd be really pleased to hear from you. So, Sarah, what's coming up next time?
Next time we will be talking about the myth of the common law spouse.
Oh, yes. So that's common law husband or wife. Yes.
Yeah. So watch this space.
Okay, brilliant. Thank you. Lovely chatting with you, Sarah.
Yes, and you. Thank
Right.
you. Bye.
Thank you for watching, everyone.
Thank you.